the Supreme Court just ruled this morning that states can count mail-in ballots late. Now, this is a big blow to Republican efforts to block the late count of what is historically a very Democratic-leaning vote. So let's bring in Stephen Caliendo to break this all down. Hey there, thanks for joining us again today.
It's great to see you.
All right, so break down, what is the heart of this ruling and what does this mean moving forward?
It doesn't. We have to take it into consideration alongside of the SAVE Act. I know you're familiar, and maybe the viewers are familiar with this legislation before Congress that President Trump really wants to pass. This is a little bit different. The case that was decided today came out of Mississippi, and it really involves states who count ballots that are postmarked by Election Day after Election Day. So the argument that the administration was making was that the RNC was making, and the administration backed, was that Election Day is supposed to be on one day. And so you vote on that day, and they count the ballots on that day, and only the ballots that come in by that day. And the Supreme Court here said, that's not right. We're not relying on the Postal Service in that way. As long as the postmark is there, then people voted on Election Day, and the states are certainly free to decide on their own if they wish to count ballots after that.
And so what states operate like this, and where does Illinois fall in all of this?
There's about 30 states, including Illinois, who allow ballots to be counted after Election Day, so long as they're postmarked by Election Day. Different states have different rules in terms of how many days they'll accept those ballots, but all of them require that the postmark be made on or before Election Day, including Illinois.
Stephen, let's talk about the timing here, because the timing is pretty significant as we're heading into the 2026 midterm election. So got to break down what that would mean, if they had to change all of this stuff just months before the midterm.
Yeah, it would have been a mess for sure, Lauren. And the other thing that would have happened probably is that the administration would have moved to challenge other aspects of mail-in voting or early voting that don't coincide with the tradition that we've had in the United States about voting on Election Day. And I must point out, one of the unique things about America is that we vote on a Tuesday, on a work day. It is not a federal holiday. And really up until, even though some states had been doing mail-in votings for a long time for anybody who wanted them, most states until COVID were restricting mail-in ballots just for those who couldn't vote in person on Election Day, namely members of the military who were overseas or other folks who were not able to vote. Now, every state, almost every state has an opportunity to vote mail-in various capacities, as well as early voting. And I think that some of the folks in the administration don't want that either. They would like people to vote on Election Day and only on Election Day.
So given all this information that we have now, is there anything that you think voters should know going into the midterm election?
No, nothing will change. I mean, what happens to the SAVE Act in Congress will matter a little bit, but it doesn't seem like the president has the votes for that. That would severely restrict mail-in voting. This case was just about when the votes could be counted. It wasn't about whether we could or could not do mail-in voting. The SAVE Act would go much further than that, stopping mail-in voting for almost everyone, with the exception of, again, those handful of constituents I mentioned a moment ago. So right now, what voters have been used to is what's going to continue, and that's what we can expect after this decision today.
Yeah, I would love to know what you think about these two competing arguments, right? You have supporters saying that this protects the voter. You have critics saying that it should all be done on Election Day. What do you make of these two arguments competing against one another?
I'm firmly in the former camp on this one, Lauren, I have to tell you. And that's because it is frustrating, of course, not to have results right after Election Day. We got so used to them. We got so used to the media making calls. And of course, media organizations make calls before all the votes are cast. We have sophisticated modeling. We're able to tell you who won an election. The suggestion, however, that counting votes after Election Day somehow opens us up to more fraud is not supported by the facts. These are not the fraudulent ballots. Just because they come in after most people voted in person doesn't make them any less valid. And so if there's an attempt to tie voter fraud or some sort of impropriety to the votes coming in late, there's really no evidence to support that. And so, I'm in favor of letting every vote count.
All right, Stephen, while we have you, we want to ask you a couple more questions about some other things going on, if you don't mind. Another ruling came down today. The president can't fire Lisa Cook from the Fed Board of Governors, but the court held that the president does have free reign to fire agency heads at will. What does this mean moving forward?
So the Slaughter case, which is not the Lisa Cook case, this is the Rebecca Slaughter case from the FEC, has wide-ranging implications. So this overturns not some 90 years of precedence in a case called Humphrey's Executor, which was decided unanimously by the U.S. Supreme Court, and said that it was permissible for Congress to set limits on when presidents could and couldn't fire members of what are presumed to be, and what over the last 100 years are presumed to be, relatively independent agencies, even though they are certainly part of the executive branch. Humphreys has been overturned. At this moment, presidents are free to fire people without cause for whatever reason they want to in all the executive agencies except for the Federal Reserve Board. As you mentioned, Lisa Cook's case was heard separately. Some of that, we're going to have to look at the language of this decision carefully, though, Lauren, because some of this pivoted on the fact that she wasn't offered due process. Unlike Rebecca Slaughter, she was going to be fired for cause. In other words, the administration believed that she had engaged in some mortgage fraud, and so they were going to fire her for cause, but they didn't offer her any process, an ability to argue that, to present evidence, et cetera. The court really took issue with that part of it, in addition to the fact that the Fed is sort of different than these other independent agencies.
Because of that, do you think there are going to be more legal challenges that come out of this then?
I don't think there's going to be an opportunity for too many more legal challenges. I think what's going to happen is Congress is going to have to decide how it wants to write laws for these executive agencies. What's really happening here is that the administration and some of the justices on the court really believe in this notion of the unitary executive that gives much more power to the executive branch, the president in particular. This is very different than what we're used to on Republican arguments or conservative arguments that limit government power. This is an expansion of government power, and particularly an expansion into the executive, bypassing what Congress wants. And so Congress can work to create new laws to tighten presidents' responsibilities with respect to these agencies. But as it stands now, that unanimous decision from 90 years ago has been overturned.
So a lot to look at today, but we're also looking ahead to tomorrow. It's going to be a big day tomorrow, right? So what can we expect for tomorrow? What do you have your eyes on?
Big day tomorrow. 4 cases left to decide. 2 of them are about trans rights. There's one about trans rights for trans girls in high school sports, and then one for trans women in college level sports. And so those cases will be decided tomorrow. The issue there really isn't whether or not trans women can participate or can't participate. The issue is whether states can prevent trans women from participating or not participating. So just if the court rules as we might expect, that states may make this decision, that doesn't mean that all trans women are banned from performing. It just means that states are able, if they wish, to have such a ban. The other case is a Federal Election Commission case that has to do with coordinated efforts in campaign finance. It's interesting to me. I don't know how interesting it's going to be to everybody else, but the big case, Lauren, of course, is the birthright citizenship case. The court is not deciding whether or not birthright citizenship is the right thing or the wrong thing for the country. What the court's deciding is, can the President of the United States, simply with an executive order and no backing from Congress, or even if Congress was backing, overturn language that seems very plain in the 14th Amendment? Most legal scholars will say this should be a 9-0 decision. Maybe it's a 7-2 decision. But as we saw with the Slaughter case, and certainly as we saw with the Dobbs case overturning Roe versus Wade a couple of years ago, this court's not afraid to turn against precedent when they want to.
Yeah, it'll be very interesting to see how it all shakes out. Stephen Caliendo, thank you so much for joining us this morning. We appreciate you.
It's great to be with you.
All right, take care.